board to order. My name is David Himmelman, and I'm the chairman of the ethics board, and I guess the record is 3 o'clock, March 15th. Mayor, would you lead us in the Pledge of Allegiance, please? Let's go out with the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
For the record, this meeting was noticed pursuant to the Sunshine Law. Notice of this meeting pursuant to the Open Public Meeting Act, NJSA 10:4-10 and 6 has been complied with and shall be entered upon the minutes. Richard, would you please call the roll?
Robert T. Dash Jr.
Present.
Daniel Frankel.
Present.
David Himmelman.
Present.
Albert Usiker.
Present.
Robert Seaver.
Present.
I do want to thank all the board members for coming to today's special meeting, given the weather and difficulties, but much appreciated. Really the seminal purpose of today's meeting is consideration of a complaint that the board is aware of, from Mr. Crowder, which I believe you were here today. This matter has been reviewed in some detail by the county counsel's office and discussions with both myself and the county counsel's office directly. As the board is aware, there was a investigative report that was prepared relative to the complaint filed by Mr. Farrell against our ethics attorney, Anthony Vignola. I presume that everyone has received and had an opportunity to review the investigative report. In my view of the report, which was prepared, I believe that quite frankly, there's just no factual or legal basis or justification to have the complaint previously filed go forward, and there's just no reasonable basis to sustain the ethics violation alleged against Mr. Vignola. And I am comfortable after reading and reviewing the investigative report prepared by the county counsel's office that in fact this complaint should be dismissed. However, I'm only one member of the board, and but I would at this point like to open it up for discussion among the board members to see further if you have any questions, concerns, or you'd like to raise any questions for our attorney who's here today, Mr. Vignola, and from the county counsel's office. So that would be the first order of business. So I would open it up to any of the members who wish to answer, have any questions answered or concerns raised. Does anyone have any issues or would like to discuss anything?
Based on the legal opinion, I have no concerns at this time.
Okay. Anyone else want to raise any issue or discuss it?
I think the research that was done and the references to the existing laws is quite comprehensive, and I don't see any justification, as you mentioned, to entertain the complaint.
Okay. Anyone have any further thoughts or questions? Okay, great. What I would like to do now is, before this board takes any formal action, either in the way of adopting a resolution, I'm going to open it up to the public for specific questions or comments about the action before us today. And if you just state your name and address for the record, that would be great.
Good evening, members of the board. Good afternoon, members of the board. My name is Charles Gradeville. You know me by now.
Just 1 second. Mr. Chairman, can I just ask you a question?
Sure.
Just as counsel?
Sure.
I have no problem, Mr. Gradeville, addressing the board.
Yes.
But is that something that we do before discussing the motion?
Well, the reason I would want to do that is because certain documents that we may want to make available to the public, including the investigative report, but I don't want to do that until after any action is taken by the board. So I'd like to have public comment heard prior to any discussion on the potential motion, the resolution.
Thank you, Mr. Chairman. And for the record, I am from New Brunswick and am the author of this complaint. You read my mind. I wanted to ask if I could see a copy of the investigative report. So I guess before the end of the day, I'll be able to get a copy.
Yeah.
Great. Thank you. I wanted to say I look forward to reading that research that the County Counsel's Office did. I did some of my own research, and if you'll indulge me, I just want to put it on the record. Section 8.01 of the County Code of Ethics is clear that every officer of the county shall annually file a financial disclosure statement with the county clerk. The County Code of Ethics is parallel to a state statute, the Local Government Ethics Law, NJSA 40A:9-22, and Section 3 of that law, it provides definitions. And definition letter E is the definition of a local government agency. And it says that it means, quote, any agency, board, governing body, it's got some other stuff there, which performs functions other than a purely advisory nature. The caveats are that it includes the chief executive, so we don't have a county executive in Middlesex. It also includes independent authorities like the Utilities Authority, et cetera. And it also mentions that it shall not include a school board. So my question for you, respectfully, Mr. Chair, do you believe that this is the Ethics Board, a local government agency?
The Ethics Board would qualify as a local agency. That doesn't necessarily rise to whether or not Mr. Vignola would fit within the definition of a local government officer requiring disclosure.
Okay, thank you. So the next definition is G that I want to talk about is the definition for local government officer. And it means, quote, any person, whether compensated or not, whether part-time or full-time. If I may.
He can exceed his law on that.
Thank you, Mr. Chair. And so folks in that category, which is part-time or full-time, there's four categories that make them a local government officer. So elected officials, if you're elected, you automatically have to comply with the disclosure requirements. Number two, if you're serving on a local government agency with the authority to either enact ordinances or approve development applications or grant variances. And then number four, this is the one that matters, it says, who is a managerial executive or confidential employee under Section 3 of the NJ Employer-Employee Relations Act, which actually goes back to 1941, and it's not really about ethics, but it's the basis under the local government ethics law for who is required to file as a, quote, managerial executive. And so if you go there to 34:13A-3, there's definitions, and definition F is the definition of managerial executives. It says they are, at least for purposes of county and local governments, quote, persons who formulate management policies and practices, and persons who are charged with the responsibility of directing the effectuation of such management policies and practices. Now, needless to say, in New Jersey, there's 566 municipalities, 21 counties, all these independent authorities, and there's a lot of different job titles that folks have. And sometimes it can vary from town to town whether folks have been filing under the financial disclosure requirements. So, a wise citizen of New Jersey proposed a rule to the local finance board to clarify which titles are required to do that. And so I'll move forward to that. That was proposed on September the 6th. It was adopted and filed with non-substantial changes on January 31st. There was a public comment period, and that new rule went into effect and was published in the New Jersey Register on March 6th, just 9 days ago. Again, that's NJAC 5:35-2.1. And I have copies of the notice that was published in the Register for everyone here. I want to make sure you get the chance to see it.
Thank you.
so it was very interesting to learn about the rulemaking process and see that during this public comment period, folks could raise concerns or ask questions, and the director of the local finance board would, or the local finance board would respond and actually even make some, as they say, non-substantial changes to that. So I just want to draw your attention to, I guess it's one of the next to last pages, page 2 here, towards the end is a comment from Ms. Kathy Reese, and she asks, she's the Warren Township Clerk, and she
Okay, I'm
asks,
sorry, what?
this would be, the pages aren't numbered, but it should be the second page that I gave you there.
Second page, okay.
And at the bottom, you'll see a comment from Ms.
Yes.
Kathy Reese.
Yes.
She's the Warren Township Clerk, and she asks that the phrase independent local government agency be defined, and actually, as a result of this comment and other comments, they decided to nix the word independent from the rule, but nevertheless, the point is clear, and this is just a quick point I want to make, that the agency responded by saying that independent local government agency is defined. It says it refers to an attorney serving a local government agency as defined in the local government ethics law, section 3, definition E. So right back where we started from, it matches up. The definition that we're supposed to use is in the local government ethics law, and it's clearly defined, and I think, Mr. Chairman, you agreed with me earlier that this is a local government agency. So I'll move on to the next comment. Right beneath that, Mr. John Reinhardt's the administrator and CFO of Wharton Borough, which I can't tell you what county that's in, but he wanted to know whether the independent local agency attorney encompasses all attorneys or ones that are directly employed by the government. So this is an important point because a lot of attorneys, especially in New Jersey, do represent boards and governments, but they do it through their law firm. It's a contract that's done through the law firm instead of a direct contract. And so this is an important question, whether or not the independent contractors have to file just like the folks who are direct employees. And here's the answer, quote, paragraph A-12 and 14 of the rule, of the adopted rule will require the attorney who is appointed to represent the local government agency, regardless of whether they are direct employees or contracted professionals, to file a financial disclosure statement along with any other attorney in the same firm as the named appointments who regularly provide professional services to the local government entity. And if it wasn't clear, they bothered to write it again. In the same answer to that question, you can continue to see, regardless of whether or not a local government agency attorney is a direct employee, said attorney is considered a managerial employee by virtue of their high level of authority and independent judgment.
I'll interject, I apologize. First of all, thank you for your submitting this documentation. I've allowed you some leeway here beyond the allotted time to speak. What I'm going to suggest at this point is, we've gotten determination from the county counsel's office on the legal issues that are raised from your complaint. If after the determination from this board, if you're not satisfied, you can either supplement your complaint or you can take the complaint to the next step, whatever that administrative processes would be. But I think at this point, I think the board is ready to make a recommendation and adopt a resolution moving this matter forward. So that's kind of where I'm at this point.
Understood. I hope that you would want to hear the full this side of the story before you make your decision.
Again, I think our county counsel's office has done a thorough and exhaustive review of both the state law and county law, as well as Attorney General's opinions, etc. And I think at this point, the board is ready to accept the investigative report that the county counsel's office prepared, which, as I indicated, they do not believe that the local ethics board attorney falls within the meaning of the local government officer as we've discussed. And my understanding is that the resolution has been prepared, and I would be prepared to read that resolution. Yes.
Mr. Chairman.
Yes.
Just to address,
You want to address one issue?
just as a point of clarification.
Okay, that's fine.
In reading the documentation that you provided, I did have a within a local government agency, individuals in these positions would not be required to file a financial disclosure statement under the adopted rule. And the reason why that is of relevance is because that is the same proposition that was mirrored in all the other Attorney General opinions that perform the analysis as to which attorneys fall under the requirement to file a financial disclosure statement. With respect to your specific complaint as to the ethics board attorney, given his special limited capacity by which he represents this ethics board, which is specifically to represent the board in their capacity as it pertains to all of their responsibilities as outlined in the local government ethics law, by virtue of that representation, it is considered to be his scope of representation is on a limited basis. In addition to that, given the infrequency that the board meets, which is essentially 3 times a year, it cannot be deemed that the ethics board attorney frequently and regularly meets and advises the ethics board. And for that reason, because he serves in a very limited capacity, he does not fall under the definition by statute and by the Attorney General opinions that have interpreted the statute to be deemed a local government officer for the purpose of filing a financial disclosure statement. Based on the statutory authority, there is no specific requirement that an ethics board attorney files. And more to the point, our code of ethics, which mirrors the local government ethics law, also does not provide for the ethics board attorney in the enumerated list of governmental officials that have to file. So, again, to address your point,
Thank you. And can I ask, respectfully, in your research that you did, was this new rule part of the thorough research that you did on this topic? Or is this the first you're seeing?
the references that are made in this rule were part of the consideration and the basis that formed the investigation report that was prepared for the board for their consideration.
Okay, well, I'll just, for the record, then say that I've contacted the local finance board and asked them point blank, under this rule, do ethics board attorneys need to file financial disclosures? And the answer was affirmative. So the local finance board believes that a local government ethics attorney should be filing, and it makes sense that they should, given their role enforcing the ethics statute. And again, the rule said that that's because of the high level of authority and independent judgment that directly affects the policies and purposes of an agency like this board, and further, that attorney would be participating in the formulation of management policies. That's the crux of the rule. And then just, if you look at that first comment, the very first comment on page 1, this is the one that makes it very clear that not only should Mr. Vignolo be filing a financial disclosure statement, but so should some of his law partners who've been doing significant work for the board.
Mr. Cradible, I believe we've addressed your specific assertions in your complaint as well as the additional documentation that you provided to the board.
Okay, and just respectfully, sir, I'm willing to sit down if you're going to reopen for the public portion of the meeting.
Well, let me just, a couple of things. First of all, I think County Council has done a thorough analysis of the research. And also, I can tell you that in my, well, I'm not acting as an attorney here, but I know that in my capacity serving as a municipal attorney, where I think the Local Government Services Act and the Local Government Board, Finance Board, has, at least early on, determined that because I was in a management type of role, that I was required to file disclosure. I don't believe that's the case here for Mr. Vignolo, and I think this rule doesn't change that. I'm not sure who you spoke to with the local finance boards, but if you want to, like I said earlier, if you want to supplement or amend your complaint, feel free to do that. But right now, I think we're in a position to move forward with you for the resolution.
Okay, will you reopen for the public portion as listed on the agenda, sir?
Sure.
Thank you.
Okay. I believe that a resolution was prepared and forwarded to all members. And I will read the resolution for the record, and then I would ask that there be a motion and a second. Whereas the complaint filed by Charles Cradible against the Ethics Board Attorney Anthony D. Vignolo Esquire was presented for investigation and failure to file a financial disclosure statement as a local government officer. Whereas the board adopted the investigative report recommending dismissal at its meeting of March 15th, 2017, and now therefore be resolved that the complaint of Charles Crowell against the ethics board attorney Anthony B. Bell Esquire dated January 31st, 2017 is hereby dismissed. Do I have a motion to adopt this resolution?
So make a motion.
Okay, motion made. Second? Okay. Any further discussion or issues you'd like to raise before taking a roll call on this resolution? Okay, Bridget, you want to pull roll?
Robert Dudas Jr.
Just one comment, Mr. Chairman, before I go.
Yes.
I would like to thank our council for the clarifications and follow-up on the documents that were submitted by Mr. Cradible. With that, I'll be voting yes.
Daniel Frankel.
Yes.
David Himmelman.
Yes, and I also would like to thank county council for their research and thoughtful analysis in providing the investigative report and the conclusions reached thereunder, and I vote no.
Albert Ginsberg.
Yes.
Robert Seaver.
Yes.
Okay, the motion, resolution is adopted, and I guess that'll be entered to the record. Is there any new business and or additional correspondence that the board want to take up? Okay. So I will open up to the public again for additional comments, but please limit your comments accordingly. Thank you.
I will, sir. Thank you for the opportunity to address you once again. First question is this decision able to be appealed? I believe under section 11.08 of the county code.
The local government ethics law provides for any appropriate legal recourse that's available to you as a result of the ethics board adopting that opinion.
So it sounds like a yes.
Yes.
Okay. And so I won't belabor the point, but if you do have time, read that first comment and response in the register there that's published. It's regarding a typical scenario that's not unlike the scenario we have. And in that scenario, it says that both attorneys, the one officially who is in the office, but also someone who they farm and work out to or have them fill in, both actually need to file. So I believe that the firm in question is Boris, etc. Boris et al. There's 7 partners there, and so far there have been 4 meetings of this board. One of the meetings since 2016, one was canceled. Mr. Vignola was at one, and for 2 others, he sent each time a different law partner of his. So I believe now there's 3 folks that ought to file under this law. And I do want to just give some suggestions for things you can do to improve the situation. Number 1, first off, right off the bat, would be to create a website so people can find you online. The Ethics Board, to my knowledge, has no presence on the fantastic Middlesex County website, which has virtually every part of the government in it. Right now, there's not a way to find you and connect with you online. It's not really clear where folks are supposed to file their complaints. They kind of have to know where to do that, and I think that securing a telephone number as well as an email address where complaints can be submitted would be a logical thing that this board should do, and other ethics boards do that. You might also want to consider a P.O. box or maybe other avenues. I think you could immediately organize ethics training on the basics of financial disclosure statements and the nuances of this recent new rule and who it might apply to and what the verdict is for them. And you could please, I think you need to immediately hire new counsel outside of this firm and terminate the relationship with them. It looks very bad to have someone who's violating the law that they're supposed to enforce. And I think you could immediately schedule 1 or more additional special meetings to execute those tasks that I just laid out. I hope you'll pursue that. I'll move forward on my complaint, and I do thank you for evaluating it. I look forward to reading the report. But I will say that going forward, there should be greater advertisement of these meetings. They should be held at a time that's convenient for working people, not 3 p.m. And I think I heard some folks talking about it. Parking should be provided for not just the board members, but members of the public who want to attend. This board should be encouraging folks to come out and having meetings much more frequently. I'll close by just pointing out some of your powers under Section 9. You do have the power to initiate, receive, hear, and review complaints and hold hearings with regard to possible violations of the county code. So again, the key word there would be initiate. The board does have the power to initiate a complaint. This was brought up at the last meeting where I was saying, I wrote a newspaper article about the county prosecutor violating the county code of ethics and the local government ethics law, and I was basically told I have to file a formal written signed complaint in order for this board to take any action. I'm telling you that is incorrect. Under Section 9.01, you have the power to initiate a complaint, to initiate this matter against the county prosecutor. And I'm encouraging you to do that. I haven't heard anything about a review of that matter, and I think that matter is perhaps even more serious. And then you do have the power to issue subpoenas for the production of documents and the attendance of witnesses. I think Mr. Vignola, it's kind of weird to say you need to subpoena your own attorney, but I think you should subpoena your attorney and have him show up here and testify.
Thank you very much. I think we've been more than gracious with allowing you to speak beyond the time.
And just as a closing comment, Mr. Cradwell, in light of the proposed new rule that you provided, please understand that there is no retroactivity applied to this new rule. So if it's, again, I haven't had a moment to review this, but the effective date is March 6, 2017. So what you've proposed and what you've set forth in your complaint would not, based on the board's decision, the application of this proposed new rule would have no effect moving forward from March 6, 2017 and forward. So it would have no retroactivity as to Mr. Vignola's obligation to file a financial disclosure statement. So with that,
For 2015 and 2016.
correct.
But for 2017, it's very good. It
Well,
does.
the deadline has not passed.
Correct.
So in light of this proposed new rule, it will.
No, it's been enacted, this one.
It'll be taken under consideration and advisement, and that's basically it.
I can tell that certain board members are in a hurry to get out of here, and I'm sorry to prolong
You've
this.
definitely exceeded your time in the board.
And could you cite the statute that has the time limit, where there's a
There's
limitation?
actually, there was a resolution adopted by the board at the reorganization meeting, limiting public comment to 2 minutes.
Really, and how was that advertised? Were the copies of the resolution available? Was this published in the newspaper?
The reorganization meeting was.
I was here, I didn't hear anything about it.
Mr. Cradwell, listen, I'm sensitive to.
What is the time limit in the, I just need the name of the resolution, the number, and the reason for the time limit, because that's news to me. I asked for a copy of the bylaws today, and I was told there are none. I was told there are no responsive documents, no bylaws, no operating procedures.
So we operate under the statute, but.
Okay, so which statute is that says that the time is limited, that a member of the public can speak? And what is the quantity of time that it limits folks to? I just want to know the
I
basis.
provide you with a copy of the resolution. I've allowed you to go well beyond 2 minutes, but at this point, we understand you've made your point, duly noted, and as Nikki indicated, we will look at the rules option from Community Affairs, Community Affairs, and if need be, we can clarify or you can supplement or amend your prior complaint. But
Deal. All right, and just last thing I do want to point out, under F, you have the power to adopt rules and regulations. That's something you should do. You should adopt clear rules and regulations for how these meetings and hearings are going to be run, and everyone should be able to get their hands on it.
I understand that.
Thank you, sir.
Thank you for your time. Okay. Any other comments or questions before I ask for adjournment? Okay. Do I have a motion to adjourn? Okay. Roll call?
Robert Dudas,
Yes.
Daniel Frankel.
Yes.
David Himmelman.
Yes.
Albert Musiker.
Yes.
Robert Seaver.
Thank you very much for your time and safe travels today.
Hey, how's it going?